My name is Giovanni. I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Recent Developments in Personal Care. Today's presenters are Heidi Kocher and Annabella Denzel. Heidi is a partner at the law firm of Lyles Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a Chief Compliance Officer and a Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers, all up to the LLJ level. She received her JD from Georgetown University Law Center. She's licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. As for Annabella, she is licensed to practice law in Indiana and is pending admission to the South Carolina bar. Her practice focuses on regulatory compliance with particular emphasis on federal Medicare and Medicaid compliance and appeals. She handles matters at all levels of federal appeal process, from redetermination through the Medicare Appeals Council. Ms. Denzel represents clients nationwide. Ms. Denzel brings an extensive experience in medical billing, coding, and compliance, and holds 2 professional accreditations: Certified Medical Compliance Officer and Certified Professional Coder. Her regulatory experience encompasses False Claims Act matters and anti-kickback statutes, and Stark laws. Ms. Denzel also attempts to grow her pre-existing experience in clinical research compliance, identifying and resolving inconsistencies or compliance deficiencies in research project proposals during the institutional review board. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the question box, and we will address as many as possible at the end of the presentation. I will also be sending a copy of the PowerPoint slides via email, so please look out for that tomorrow. So without further ado, I present your speakers, Heidi Kocher and Annabella Denzel.
Thank you so much, Gio. I'm going to be handling the first half, and Annabella will be handling the second half of the webinar. And just before we dive in, I do want to remind everybody that this is educational information. It is not legal advice, and nothing in today's session is going to create an attorney-client relationship between either Annabella or me and you or your agency. If you have specific legal questions, please consult with your own counsel, because the details often matter. Again, as said, we are not your attorneys, and your mileage may vary. All right, next slide, please. So what we're going to cover today are some of the things that have happened in the last couple of years, and then look forward. So we're going to talk about some 5 developments that drive compliance risk. We're going to talk about the Texas attendant workforce legislation. We're going to talk about some administrative rulemaking, EVV, always a hot topic, some revisions to the HHSC handbook, the CMS Medicaid access rule, and the 80/20 rule, and then the DOL's Department of Labor's proposed companionship and live-in exemption rule, and some other federal developments. Then Annabelle is going to take over and talk about the recent, last month, 2026, June, DOJ National Healthcare Fraud Takedown, how this reaches out and affects you all, Texas-specific impacts of the takedown, some national PAS litigation and wage hour exposure, and then some practical compliance takeaways. Next slide, please. So again, we've got sort of 5 major developments that are driving compliance risk for personal attendant services and more generally home health and hospice. The first is that the Texas attendant wage and rate restructuring of Rider 23 in 2025 raises the assumed personal attendant base wage rate to $13 an hour. It increases the payroll tax and benefit load assumptions and discontinued the ACRE program effective last September. I think most of you have worked through this already, but we're going to mention it anyway. EVV and related licensing has tightened. EVV, I know, is a perennial sore spot for everybody, but they have extended some of the compliance grace periods, even though full enforcement began a year and a half ago. And SB 240 and SB 463 extended workplace violence prevention obligations to PAS only agencies, and we'll talk about that in a little bit. The federal Medicaid access rule is in flux. That is known as the 80-20 rule. And CMS requires that 80% of certain payments that must flow to direct care worker, there we go, compensation. And compliance isn't due until 2030, but there is pressure in Congress to push for repeal of that. So we'll talk about that a little bit. The federal wage and hour rules have also reversed in direction. DOL had a proposed rule that would restore the pre-2013 Fair Labor Standards Act companionship and live-in exemptions for third-party agencies. And DOL has already told field staff to stop enforcing the 2013 rule, so we'll talk about that a little bit. And then again, Annabella will do a deep dive on the June 2023 takedown, where we had one of the largest Medicaid fraud caseloads in DOJ history. They charged 455 defendants and included PAS, home health, and pill mill cases all over Texas. So very important topics that you need to be aware of what is happening. Next slide, please. All right, so we are going to jump into, again, the attendant workforce legislation. The first thing here is the workplace violence. So SB 463, which was passed in 2025, amended Texas Health and Safety Code Section 331.003 to clarify that all home and community support service agencies, my tongue is tied today, including agencies that are licensed only to provide personal attendance services, must adopt a workplace violence prevention program under Chapter 333. The caveat here is that if the agency employs 2 or more registered nurses, regardless of what capacity you employ the nurses in, then this chapter applies to you. Even if the RN doesn't do anything in the field, if you employ 2 RNs, you must comply. So the first deadline was in September 1st of 2025. HHSC Provider Letter PL 2024-10 set out that compliance deadline. And by the way, when you get the slides, there are links in them. They're hyperlinked. So the original SB 240 gave a deadline of September 24th. They extended it for certain circumstances to September 1st, 2026. So that would be coming up. And they're now amending 26 Texas Administrative Code Chapter 558 to align licensing rules with both SB 643 and SB 240. So again, make sure that if you employ 2 or more agencies, you are working in terms of doing the workplace violence program. Next slide, please. So again, what they did is they redefined covered quote-unquote facilities to include HCSSAs that are licensed and certified that employ 2 home health, 2 RNs. The covered agencies have to establish a workplace violence prevention committee. You have to adopt a written policy about workplace violence prevention and a plan to implement that policy. And then you have to provide annual training to staff. The compliance deadline was September 21st, 2024. So it's a year and a half ago now, almost 2 years ago. Note that non-compliance itself is not going to create any civil or criminal liability just for not complying, but it will result in and support any HHSC licensing discipline against your agency. So you do want to make sure you have been working on that. Next slide, please. Okay, so the next topic is the attendant wage and rate restructuring. I know this has been a topic for many, many people. So the 2026 and 2027 General Appropriations Act, SB 1, Rider 23 actually directed HHSC to raise the rate for personal attendance in the Medicaid rate setting process to $13 per hour. It increased the assumed payroll tax and benefits load to 14% for community-based attendance services and 15% for residential and facility-based services. This also discontinued the Attendant Compensation Rate Enhancement Program, the ACRE program, and that was effective August 31st, 2025, so last year. And again, they replaced it with the adjusted base attendant rates effective September 1st. So HHSC implemented Rider 23 through Texas Administrative Code rulemaking, Section 3, and through the information letters 2025-11, 2025-17, and 2025-2025. The point for here is that if your agency was budgeting around the old ACRE enhancement payments, those are now gone as a separate line item. Those dollars show up in the base rate instead. So you want to go ahead and pull your actual remittance data from September 2025 forward and compare it to HHSC's PHC and CAS rate sheet, which we'll talk about in a minute, to confirm that the new rates are in fact landing as expected. Next slide, please. So again, effective last year, they repealed TAC 355.112 and adopted a new 355.7052, establishing this revised attendant cost rate methodology. They retitled 355.7051 to base wage for personal attendant before September 25. So again, they have now a separate rule for before 2025, September 1st, 2025, and then one for after September 1st, 2025. There are related amendments scattered throughout the Texas Administrative Code. I am not going to go into all of those because that would take up all time on our webinar, but just know that there were some changes to all these other sections as well. Next slide, please. Okay, some good news actually in terms of citations and due process. So for citations effective beginning April 1st, 2025, HHSC updated the CM Pass and Class CFC cross-references following HB 4611 recodification of the government code. That's a lot of legal gobbledygook. Just be aware that they rewrote the government code and they updated the citations. HHSC has characterized these as non-substantive with no fiscal or programmatic impact, but you need to be aware of them because if you get cited, they're now citing to different sections than you may be used to from previously. Another good thing is for the Rider 23 wage increases. In order to prevent the increase from pushing individual service plans over applicable cost limits, HHSC proposed parallel increases to waiver cost limits across class, DBMD, TXHML, and HCS programs. So those should be hopefully moving forward. We'll cross our fingers on that. And here's the big nice thing, and this is both good news and bad news. So effective August 14th of 2025, they made some changes to due process and hearings. So the bad news is that HHSC can consider a deficiency that is still under administrative review when deciding whether to impose an enforcement action. So they don't have to finish their review of a deficiency before they decide to move ahead. The other part is that all of your due process rights have to be exhausted before HHSC finalizes an enforcement action. So that's actually a good thing, but it's also coupled with the not so good thing, which is that any records requests tied to administrative review must be made within the same 15 calendar day window as the request itself. So when you get a potential citation and you request a review, you have 15 days to request a review. You have to request all the records from HHSC during that same time frame. You cannot extend the time frame. You cannot go beyond it. If you are beyond the 15 days, so sad, too bad. So it's both a good thing and a bad thing. You now have the explicit right, but that right is limited, as I said, to 15 days after the citation. Next slide, please. Okay, so EVV, as I said, this is always a sore topic. I know there's a lot of work that everybody has done with EVV. So just to recap, of course, for fiscal year 2024, HHSC transitioned everybody from the legacy Authenticare and Vesta systems to a single state-funded aggregator, HHA Exchange, which of course has been operative since October 1st of 2023. Effective January 1st, 2024, OT, PT, and in-home nursing services became subject to EVV, joining personal care and home health aid visits, which had already been covered. Effective January 1st, 2025 was the end of the compliance grace period and enforcement began. So all providers, FMSAs, and CDS employers who failed to meet the 80% minimum EVV usage score or the other requirements that may be applicable to you became subject to contract and enforcement action. And I'm sure you're seeing that EVV claims with no matching visits on or after January 1st, 2024 have been denied. So what's coming in is they are in the process of phasing out alternative clock-in, clock-out devices for service providers and CDS employee visits. The full phase-out is anticipated by January 1st, 2028. And I know I see on the open forum, all kinds of questions come flying across about EVV issues. Like I said, always a sore topic. There are some ongoing policy handbook revisions. They are going to continue refining required data elements, visit maintenance unlock request procedures, and reporting. And this is strictly at the Texas level. So just remember that the 21st Century CARES Act, Section 12006, was the impetus for the EVV mandate. It remains the federal EVV mandate, and there are no changes in this period, and I don't think we are going to see changes. There's just not appetite for that in Washington, D.C. Instead, we are looking at Medicaid work requirements and other things. So I don't think we'll be seeing any changes on the EVV requirements. Next slide, please. There have been some changes to the Community Cares Services Eligibility Handbook. And remember, this handbook governs how PHC and CAS caseworker procedures go forward and how they do that in the field. And they've received numerous revisions within the last couple of years. Section 460, dealing with primary home care and community attendant services, had revisions effective September 1st, 2021 and December 1, 2025. These updated eligibility verification procedures, including the tiers, Medicaid eligibility steps, and family care referral rules, while community attendance services financial eligibility is pending. They updated Section 270, service monitoring changes and transfers. Those changes were effective November 1st, 2024. And those changes reaffirmed the requirement that HHSC caseworkers must conduct a face-to-face 90-day monitoring visit for CAS recipients. And this is a requirement under the Federal Social Security Act. Section 280s, notifications, suspensions, denials, and terminations. Those changes were effective September 1st, 2025. They're relatively minor, but they refined what the contents requirements are for a notice for adverse PAS actions. So always really important to look at those kinds of things because sometimes their notices are deficient. And then finally, Section 2900, appeals and fair hearings. It clarified that there is the amount and the level of coordination between HHSC access and eligibility services and the appeals and mitigation staff, and the continuation of benefits rules pending a fair hearing. So these might not be really major things for your business. It really does more deal with how HHSC is supposed to operate. But HHSC is supposed to operate in accordance with their rules, and you need to make sure that you hold them to how they are supposed to operate. Next slide, please. The next topic is the HCBS interest or waiting lists. I'm going to talk real briefly about Olmstead because this mentions Olmstead. Olmstead was a federal case from a number of years ago, and it was a Supreme Court, actually it's more than 20 years ago, it was 1999. Wow, that seems a long time ago. And essentially what the Supreme Court held was that under Title II of the Americans with Disabilities Act, unnecessary institutionalization of people with disability constituted unlawful discrimination. And so public entities have to provide services to people with disabilities in the most integrated setting appropriate to their needs when, number one, the state's treatment professionals determine that community-based placement is appropriate. Number two, the individual doesn't oppose community placement. And three, community placement can be reasonably accommodated given the state's resources and the needs of others receiving similar services. So essentially what this did was mandate that states administer services in quote unquote the most integrated setting appropriate, unquote. And this case really gave that the ADA teeth. And so what it did is it reshaped Medicaid long-term policy, and it is what precipitated the shift from institutional care towards home and community-based services and waivers. It created ongoing state compliance obligations. Many states operate under Olmstead plans, and many states remain subject to DOJ enforcement actions and private litigation for failing to offer sufficient community-based alternatives. And generally speaking, and most importantly, it influences the hospice and HCSSA regulatory context because it's part of a larger, broader backdrop for how states structure home health, hospice, and community-based licensure, because it reinforces the policy preference for community and home care-based delivery models over institutional settings. So that's why there is a reference here about Olmstead. It kind of sets up this entire regulatory schema. So Texas continues to maintain very long interest and waiting lists for HCBS waiver programs that include attendant and personal assistance services, so CLASS, DBMD, HCS, TXHML, MDCP, and the STAR Plus HCBS. We have information that well over 100,000 Texans are on the combined waiver interest waiting lists as of late 2024. There has not in the last couple of years been a Texas-specific Olmstead enforcement action or consent decree, but HHS Office for Civil Rights has been active on the Olmstead HCBS wait list in other states, and specifically Rhode Island, Delaware, Iowa, Illinois, Idaho, and Alabama in the last couple of years. So if they are focusing in on those other states, it is possible that they could apply those principles and procedures and practices if Texas's waitlist practices are ever challenged. With well over 100,000 Texans, I would think there would be some interest. As you are all aware, however, Washington is in a bit of turmoil. I'm not sure if HHS Office for Civil Rights has this focus right now. I think there is a lot more focus on religious freedom right now from HHS Office for Civil Rights. So just FYI. Texas did lead a multi-state challenge to revise the relevant Section 504 regulations. And this is part of the broader landscape. There is nothing new to report on that, but just be aware that the waiting lists are a concern and may be the subject of lawsuits and regulatory access coming forward. Next slide, please. So the next thing we're going to talk about is the Medicaid Access Rule, aka the 80/20 rule. So this final rule was established in May of 2024, effective July of 2024, and its key PAS-related provision is a new Section 42 CFR 441.302 subsection K. And this applies to homemaker, home health, and personal care services delivered through the HCBS state plan authorities demonstrations. And so they are both for fee-for-service and managed care lookalikes. And what this rule requires is that at the state level, a minimum of 80% of the Medicaid payments for those services must be spent on direct care worker compensation, and it's measured at the individual provider level. You can see how this ties in with the $13 minimum wage rule as well. Some of the excluded costs are training, travel, and PPE costs for direct care workers, so you can subtract those before you compute the 80%. And there is a self-directed carve-out. It does not apply to self-directed models where the beneficiary sets the worker's pay rate, but it does apply to the agency with choice and other fiscal intermediary models. So something to keep in mind. In terms of what the timeline is for this, data collection is supposed to begin in 2028, and the 80% minimum performance requirement itself does not take effect until 2030. Of course, given how far away 2030 is and even 2028, there are chances that this might not come to pass. But you should be thinking about how you are going to be collecting this data and reporting it. Don't leave your potential compliance actions until the last minute in the hopes that this will not go live. That's not the way to go about these things. Next slide, please. As mentioned, the 80-20 rule, as of this presentation, has not been rescinded. However, there is congressional pushback. In February of 2025, 9 House Republicans, including Texas Reps Dan Crenshaw and August Pfluger, did write to President Trump urging repeal of the 80-20 component and its reporting requirements. Commentary throughout last year has predicted that the rule would be either rescinded administratively or simply not enforced, but no Federal Register rescission notice has yet occurred. In early 2026, there was a related delay. CMS delayed enforcement of a related access rule requirement, which is the HCDS Related Parties Advisory Group, and it announced that it would not enforce a July 9th, 2026 and July 9th, 2028 deadline if the states convene the group by January 1st, 2029. We don't know if the states are going to convene that group, obviously, so we're just kind of waiting. So the bottom line is that the 2030 compliance date hasn't changed, but it's looking like enforcement leniency may happen under the current administration. But don't forget, we have a presidential election in 2028. So it is entirely possible that if there is a new administration, that 2030 compliance goes ahead. So you should really plan for compliance by 2030, even while all this politicking is going on and the potentials exists for changes. Next slide, please. Another thing that has happened is the Department of Labor made some changes to the companionship and live-in rules. So on July 2nd, 2025, Department of Labor's Wage and Hour Division published a proposal that would rescind the 2013 final rule, which was effective 2015, and restore the department's prior 1975 regulations. And what it does is, this is again a proposed rule, but it would restore third-party employer eligibility. So it would be that home care agencies, not just the individuals or households who directly employ a caregiver, but the agencies could again claim that minimum wage or overtime exemption for companionship services and the overtime exemption for live-in domestic workers. The 2025 proposed rule actually removed the 2013's rule, 20% of hours cap on ADL tasks, dressing, bathing, etc., that could fall in with the companionship exemption. Why is this important? The many Texas PAS and primary home care and community attendance services, attendants are employed by third-party HCSSAs and perform precisely these tasks. So a final rule would materially affect overtime and minimum wage exposure in a positive way for Texas PAS provider agencies. And I know that Rachel submitted comments on this rule, and so your TAC is fighting for you guys in that sense. Next slide, please. So in the meantime, on July 25th, 2025, the Wage and Hour Division issued a Field Assistance Bulletin number 2025-4, and it actually instructed field investigators to immediately discontinue enforcement of the 2013 rule, including any pending open cases against third-party employers. Now, this bulletin does not affect private rights of action, and the 2013 rule remains law on the book pending a final rule. The comment period on the proposed rule closed September 2nd, 2025, and no final rule has been published as of today. There has been some legislative pushback. Senators Patty Murray and Andy Kim and Representative Alexandria Ocasio-Cortez introduced a Fair Wages for Home Care Workers Act that would codify the minimum wage and overtime protections in response to these Department of Labor proposed rules. That obviously has not moved. And I heard last night that Congress has basically adjourned, I think for the summer. They've gone home, so certainly for the 4th of July holiday. So at least for a while, there is going to be no movement on this front. One other thing to mention is that there is case law out there, and the Sixth Circuit in the DOL versus AmeriCare Healthcare Services did affirm the DOL's delegated authority to define and redefine these exemptions by the same authority that DOL is now using to attempt to recourse. That's one of those how to make pasta kinds of things, how you're making the sausage. But basically, it said the DOL has the right to make these kinds of changes. Next slide, please. Last slide on my topic. Medicaid work requirements, I mentioned this earlier. The One Big Beautiful Bill signed last year imposes new Medicaid, quote unquote, community engagement requirements on expansion population adults beginning January 1st, 2027, and it moves redeterminations to a 6-month as opposed to annual cycle. How is this relevant to PAS? Well, most PAS HCBS attendant care recipients actually qualify through disability or age-based pathways, not the ACA expansion group. But these new verification systems, accelerated redeterminations, and a proposed or a forthcoming CMS medically frail exemption rule, which was released just in June, could affect dual eligible or marginal PAS recipients. So that's something to be aware of. Also, CMS proposed rules to implement a section of the 2025 reconciliation legislation limiting state-directed payment rates for inpatient and outpatient hospitals, nursing facilities, and certain academic medical center services. And those begin with rate periods on or after July 4th, 2026. And this doesn't directly target PAS personal care rates, but it sort of signals the broader fiscal guardrail CMS is taking on Medicaid managed care financing, and it could indirectly affect the STAR++ rate setting for attendance services in Texas. So something you guys should maintain just general awareness of going forward. Next slide, please. And I think, Annabella, this is your section now.
Yes, thank you, Heidi. So today I'm going to talk to you all about the National Healthcare Fraud Takedown that occurred last Tuesday. It was announced in the morning, last Tuesday, June 23rd, and it is one of the largest healthcare fraud takedowns in U.S. history, DOJ history specifically. We saw 455 defendants charged, including 90 doctors and other licensed practice medical professionals. We saw over $6.5 billion in alleged false claims, over 56 federal districts, and 45 different states and territories. Texas was one of the largest fraud enforcement states with, I believe, over 35 cases, which we'll get into. The Medicaid fraud caseload was also the largest in DOJ history, with over $500 million in alleged false claims. And all 50 states were involved in this Medicaid takedown. So each state's fraud control unit was involved, all 50 states. We did also have over 1,000 providers that were suspended by CMS, and then over 1,400 who were revoked entirely from billing privileges. Finally, we had almost 930 DEA actions involving prescription drugs and prescribing authority. Next slide, please. So as I said earlier, we had several thousand suspensions and revocations through this CMS takedown. 48 civil monetary penalties came out of this, totaling more than $73 million. Exclusions, like I said, over 1,400 providers were excluded nationwide, and 25 actions came out seeking more than $10 billion in payments from the Medicare Trust Fund from suspended before paid claims. We also saw civil charges accrue with 13 defendants and $14.8 million in penalties, and settlements with 31 defendants and over $23 million in penalties. Like I said, the DEA had almost 930 administrative actions related to controlled substance handling and prescribing as well. In essence, this was a massive, complex takedown from the both criminal and civil side that saw cooperation amongst all different levels of government as well as interagency. Next slide, please. So the PAS specific allegations luckily did not come out of Texas. We did see Alaska, Missouri, and Missouri have two types of fact patterns that came out that we want to make you apprised of. First, the state of Alaska charged a defendant with medical assistance fraud for submitting false claims as a care attendant for regularly attending the Medicaid patient's health and hygiene while the recipient was hospitalized. So this is a classic false claims scenario where services were paid for that were not actually rendered. In Missouri, we also had similar cases with two providers, Carolyn S. McGinnis and Kevin Oliver, who were also doing this False Claims Act style fee for services not rendered. All of these charges are not finalized yet, though, so I want to just make sure that we are aware these are not final charges yet. Next slide. So how does this impact you in Texas? The personal care attendant fact patterns, they're going to be something you want to make sure you are addressing in your own practice. If it's a small time practice and it's just you, obviously make sure that you are not doing anything that raises false claims alarms. But also if you're supervising or overseeing a larger PAS practice, you want to make sure that every provider in your practice is avoiding these false claims and fact patterns. Next slide, please. Excuse me. Okay, so the Alaska and Missouri cases are showing how nationwide the Home Health and Hospice Agency is seeing higher enforcement in billing for services. The Texas enforcement patterns are involving home health licensure and DME billing rather than PAS attendance in this particular takedown. However, that's not to assume that DME related matters or home health licensure matters do not address your practice as a PAS provider. These things are oftentimes looped in with one another and seen as synonymous, even though legally we understand that they are not. Another thing we always want to make sure is that we are checking for falsified visit notes, duplicated visit notes, any timesheets that are not fully or accounted for. So you have a supervisor that is verifying all timesheets. As Heidi mentioned, there are several EVV concerns. You want to make sure that your clock ins and outs match, that your documentation maintains a level of distinction from each visit, so it doesn't look exactly alike. And you're making sure that any technical difficulties that may occur with the EVV, that you're catching them ahead of time and making note of them in the case of, a corrupted note or what have you. You also want to make sure on a revolving basis that there is no issue of referral kickbacks or recruiter kickbacks in your practice. The Texas MCFU takes this very seriously. And similarly, False Claims Act exposure generally goes up the more heightened the enforcement efforts are on a practice subtype. So PAS, home health, hospice, really on any long-term care practice types are seeing heightened enforcement at the moment. So you really want to be careful. Next slide, please. So with the fiscal year 2025 judgments exceeding $6.8 billion in False Claims Act settlements, we saw almost 1,300 qui tam suits or whistleblower suits filed, and 401 new investigations were opened in fiscal year 2025. Non-PAS specific False Claims Acts were independently verified, but what you really want to know is that the enforcement efforts, like I said, are only getting more stringent, more intensive, and more persistent as you go. So especially in this fiscal year, you want to make sure that we're fixing any issues or deficiencies you see in your practice when it comes to compliance in terms of visit verification and documentation. You want to correct anything from last year that you can in this year. Next slide, please. Attorney General Ken Paxton, like I said, he and the MFCU of Texas played a key role in the nationwide DOJ takedown. Texas federal prosecutors also brought down some of the takedown's largest individual cases. As you know, these cases are going to be in federal court, and so oftentimes Texas district courts will take these cases on. Next slide. Like I said, Ken Paxton and the MFCU of Texas were involved in not just Texas-based takedown, but in many other states. They ended up taking down and helping with 30 defendants with $177 million in fraudulent billing alleged and $1.7 million in alleged illegal kickbacks. The $10 million unlawfully diverted pills were also part of that takedown. Next slide, please. The primary takedowns in Texas are the following. So we had a skin substitute graft scheme of $906 million where a nurse practitioner was allegedly charging for medically unnecessary amniotic allografts. The government ended up seizing more than $30 million in bank accounts, an over $500,000 Ferrari, and other high-end vehicles, as well as other personal effects. Similarly, a pill mill opioid diversion program was taken down. As you can see the names there, they were charged with distribution of controlled substances and conspiracy connected to 2 Houston pill mill clinics and a Conroe pill mill pharmacy. Mental health, the mental health industry also saw a $16 million scheme with the named parties charged with healthcare fraud, conspiracy, and false statements. These were False Claims Act and just alleged fraud. And then Nevada, the Nevada nurse practitioner that was charged via the Texas Strike Force. She was charged with conspiracy to commit wire fraud and healthcare fraud through telehealth. Next slide, please. Finally, the Western District of Texas, or San Antonio, we saw criminal charges against Ms. Charles with another Medicare False Claims Act fraud scheme, just a billing for services not rendered. Similarly, we saw a takedown in the Northern District of Texas against Mr. Adams for conspiracy to acquire controlled substances by fraud in connection with a fraudulent prescription scheme. So this was not quite a pill mill scheme yet, but it was rounding out to be. Next slide. So no takedown press release came from Texas that specifically talked about PAS related services. However, we did see Godwin Oriaki in Houston have his home health agencies taken down. And like I said, PAS related industry is oftentimes tied in Texas to home health and or hospice. So we want to take anything we can from this instance and see how we can translate it into your practice. Here, Mr. Oraki ended up pleading guilty to conspiracy to commit healthcare fraud and money laundering. He defrauded Medicare as well as Medicaid in Texas with through kickbacks to patient recruiters, employees, and physicians, as well as some alleged paying for claims not rendered or services not rendered. There were several co-defendants in this case, and Mr. Oraki ended up with 40 years in federal prison. Next slide, please. We're running out of time, so I'm not going to go through all of these, but these are more instances of home health and attendant-based care enforcement in the past 3 years. Like I said, not all of them are due to or related to PAS specifically. However, like I said, home health and hospice and other attendant care related cases are relevant to your practices. Next slide. So some PAS specific litigation has occurred. These are in New York. However, like with the non-PAS specific cases in Texas, I want to give you outside, not directly relevant information so that you can pull it into your practice. They're also going to show the trends that are going on nationwide that might affect Texas. So in US versus New York State Department of Health in 2026, we saw that the sole fiscal intermediary for New York's CDPAP program, the alleged complaint was that it was a sham bidding process that misrepresented the staffing and financial readiness of the practices, and it was causing unauthorized profits. The DOJ sought, an injunction, which would have caused a revenue freeze, and New York was disputing the suit's merits on its head. This is an ongoing matter, so we will see how this affects PAS in the future as that decision is made. Finally, Calderon versus Public Partnerships. This is a this is a wage dispute issue. discussing payroll violations and a PAS's ability to, excuse me, PS's ability to pay their employees on a proper compliant basis. Next slide. Regarding the federal wage and hour litigation in AmeriCare, in October 21, the Department of Labor brought suit alleging that AmeriCare had been improperly paying overtime to their home care workers for several years. The court ended up holding AmeriCare liable for that unpaid overtime under the 2013 rules. And this is important because it does affirm the Department of Labor's authority to define and redefine these really key terms in what in the specifics of your practice and compliance with federal rules. Like I said, this does directly affect the legal landscape of every provider, so we need to just keep in mind that this is going on. Next slide, please. So what can you do to be making sure your practice is ready in case of an enforcement effort, or what can you do to prevent enforcement efforts in the future? First, you want to screen and rescreen your employees. A recurrent exclusion screening is going to be the most helpful way to mitigate compliance risk, because you're making sure that your employees are always enrolled and eligible to be paid for claims to Medicaid or Medicare. You want to really make sure that you have EVV locked down. Like we talked about earlier, this is a perennial issue. We will be seeing adjustments and changes to this area of the practice constantly, but making sure that we're up to date as best as possible and mitigating any problem areas or risk areas in our EVV process is crucial. We want to make sure that we are complying with the Rider 23 $13 an hour range for now. Whether it becomes final or not, we will want to also address the Department of Labor's companionship / live-in exemption, pending its finalization, of course. Also, as I said, don't assume that just because a new notice from the Department of Justice or the Texas OAG comes out, just because it doesn't directly address PAS, don't put it aside. Let's read it, make sure that it doesn't have anything to do with you, or even if it has something to do with exclusively home health, hospice, or outside personal care services, that you're making sure it can't also be applied to you in some indirect way. We want to be documenting medical necessity and eligibility rigorously for every hospice and home health certification. In my personal experience with appeals at issue currently, one of the largest denial rationales is for lack of medical necessity based on the fact that the details were not sufficient. So we want to make sure that every detail possible is included in the documentation, and we also want to double down on those details, especially if they are key points in the patient's care. So anything that is criteria for eligibility, don't just put it in that medical record once or twice. You want it in there as many times as it is relevant. Also, you want to make sure that you are auditing your referral relationships to ensure that there's no kickback or recruiter-based referral issues going on there. And last thing, but not least, for sure, we definitely want to track that 80/20 rule and the CDPAP / PPL litigation, because even if you're not in a self-directed model, these are going to shape how the STAR Plus and consumer-directed services programs are run in Texas going forward. Next slide. I believe that is it. Yes. So if you all have any questions for us, let me look at I don't see any questions here.
Yeah, it doesn't look like there's any questions. Here's someone just
Okay,
close
well,
off.
thank you all for coming. And
Uh,
if you have any questions, please feel free to reach out to Heidi or I.
yep. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Heidi and Annabelle. Uh, Everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lyles Parker. Have a good Wednesday and take care.
Thank you all. Bye-bye.